Mr. Audlehelm.
May it please the court, counsel. My name is John Audlehelm. It is always an honor to be before this court. What we have today is the case of Christopher Roby, which is hopefully the last in a chain of cases that began with the Supreme Court in Miller, that this court extended the holding of, the reach of in Pearson, Ragland, and Null, that this court extended to all juvenile mandatories in Lyle. Then the court recently addressed the issue of whether the sentencing structure can be continued as to life without prison sentences, even the potential of them in suite. And now we have what is ultimately the last logical question in that chain. Before I get too much further, there are two preliminary matters. My client was adamant that in the event that the court orders a remand or the sentencing structure is maintained and he proceeds on to a PCR, he was adamant that the record does not portray him accurately, and he wanted a pre-sentence investigation report ordered, as it has been in several other juvenile mandatory minimum resentencing cases. And my request, if the court continues with the mandatory minimum sentencing structure, I would like a clarification as to whether the standard of review is de novo or abuse of discretion, because it's been unclear and kind of back and forth. Proceeding on,
all you think you need if we were remanded for sentences, another PSI? I mean, don't you think that defense counsel has an obligation to do more than just argue a PSI? I mean, if you read the U.S. Supreme Court case of Wiggins, where they said the death penalty sentencing, you just can't show up in court. You have to do stuff. I mean, isn't this akin to, you know, that type of sentencing procedure, which we have not seen before in the state of Iowa?
well, I think the question kind of answers itself, because the fact that we haven't seen this type of sentencing procedure before means we're flying blind, and people at the trial court level aren't really sure what we're trying to accomplish.
Shouldn't defense attorneys be able to figure out that you just don't show up in court and you argue a PSI?
I don't disagree with those assertions. I would just, this case law hasn't existed for long enough for there to develop a body of essentially ineffective assistance of counsel claims that I could cite to answer that question. Although I would certainly agree that trial counsel's performance in this, more could have been done. I think that this resentencing hearing descended into kind of a lawyer debate competition.
Are you familiar with the recent Iowa Law Review article that talks about what needs to be done in these sentencing for juveniles?
I am not. I did not read that. What's the suggestions?
Do more than just argue the PSI.
Well, and I would agree with that. I think that the real goal here is, the real question here is, if we focus on what should be done at these resentencing hearings, one of the things we're missing is, what is the goal of these resentencing hearings? And the explicit goal of these resentencing hearings has been to have trial court judges affirmatively select a small number of these offenders that they can deem are incorrigible, or whatever the irredeemable, or whatever the term is, and affirmatively select them for harsh punishment. And the point,
the incorrigible doesn't really make sense, does it, in the context of a sentence that's not life without parole or its de facto equivalent? I mean, that's not what we're talking about here. So why does the court have to determine that the person is not capable of rehabilitation? That seems to me that would be something that would apply under Miller and Ragland and those kind of cases, but not here.
yes, that's a good point of distinction between this case, because we're talking about, at this point, what we're talking about with Lyle and with Roby, and I suppose there are numbers that could be added together in different combinations, but basically at this point we're talking about a mandatory 7 on a 10 for Lyle and a mandatory 17.5 on a 25 for Roby. So those aren't geriatric release dates, and I think that the mandatory 7 on a 10 for Lyle, I mean, there are policy arguments on that side to say that the court should stop where it is. But based on the precedent in Sweet, I think the way that Lyle went was, Lyle's position was these sentencing factors are not crime-specific, so they shouldn't be punishment-specific. So Lyle chained it down to all mandatory minimums. Then as the state began to do these resentencing hearings more, we began to see how haphazard and all over the place the results were.
Well, let me challenge it just a bit and see where this goes. But building on what Justice Mansfield has suggested, there's a spectrum, really, and it's even a chronological spectrum. Early on, when you have a juvenile who's incarcerated, the science tells us that the brain won't mature until 25 or mid-20s or whatever. And there's a period of time where we just don't know what we're going to ultimately deal with. The state's case for mandatory incarceration of someone that we haven't had a chance to fully evaluate is strongest there. It's weakest at the back end. If you go down the chronology, it's weakest when you say life in prison without possibility of parole, because what Justice Mansfield was alluding to, the consequences are highest at there. Your client on the spectrum that I've just described, you know, is well away from life without parole. Arguably is somewhat closer to the period of time where the state's interest might be the strongest. So it seems to me that saying that Sweet necessarily applies here may not be quite right, because the consequences of error analysis is different, and the state is entitled to an opportunity at least to see what happens with character development and so forth. Do you see this thrust of my concern? I think you do.
I do. I think that the real question is, since Sweet and Lyle are constitutional issues, I think the way that I kind of framed it in my mind was, does the fact that we're not talking about geriatric release or life, does that switch it back into the range of things that, per separation of powers, the legislature is entitled to handle and the courts should keep away? Is that something like that?
But in Sweet, part of the concern was it seems to me, the consequence of error. I mean, it was just a decision is made, it's irretrievable, it's for life, it's done, period. And the interest in avoiding a potential error there is at its highest.
Well,
and here, I mean, I understand your position, of course, but the interest of the state is at least somewhat stronger, it seems to me, in a situation where you're closer to the age of maturity than you are in a situation where you throw away the key, there's no hope, there's no nothing. I mean, it seems to me you need to convince me and convince other members of the court that as we go down the chronological continuum, it gets more difficult for you, I think, to some extent. The risk calculus changes at least somewhat. Don't you agree?
Well, I do, and I think there's a lot to unpack there, and this is there's a lot of different things to talk about. There's so much that I think that the real focus again is on the real risk is on arbitrary imposition of the sentence, because the explicit, well, okay, now here's where I should start. With Sweet, the reason why Sweet is a guy can be a significantly influential precedent is because Sweet was talking about the factors that are the same factors that are being used here. And that's been my whole concern, is that when we have the exact same factors and they produce haphazard, chaotic results, And the explicit goal of the factors is that trial court judges have an affirmative obligation to identify the worst offenders. And we have those same problems in Sweet, and they continue on down to here. The fact that
But that's not, you know, that's, in Sweet, for example, we were concerned that, and there's a passage talking about, well, when the offender approaches 18, does that mean that the Sweet analysis or the Lyle analysis or the Miller analysis is eviscerated? And we said, well, the fact that you turn 18 isn't very helpful on the issue of irretrievable personality because it develops into age 25. But the Miller factors are factors to be considered by the district court as mitigating factors. In some cases, they'll be strong, in some cases, weak. And, you know, quite frankly, your record has some strengths and weaknesses to it, you know. I mean, there's not much on family history in the record, for example, and that's just what we deal with. But is it that difficult to apply the 5 Miller factors based on a record that's developed with the understanding there's a presumption against mandatory minimums, and the district courts are directed to work through these 5 factors? And in some cases, it's going to be clear that no parole board would likely let someone out on early release. I mean, right? I guess I'm having trouble seeing. I mean, I understand you lined up the cases in, you know, the 8, 9, 10 cases, and you went through the factual permutations, but of course the facts were different in all the cases. Go ahead and respond.
Well, yeah. Again, a lot to unpack. Yeah. The court said something during that question. The court said presumption, and I think where this goes next is, particularly now that the court has unanimously decided Breeden a few weeks ago, what if the trial courts continue to impose these mandatory minimum sentences? I think the cases are wide open for challenges on Apprendi and Blakely, and I think that could be the next area where this case goes. And so some of the argument that I've tried to make is it's not so much about Roby per se, but it's more of a judicial economy argument, because the question is, if we're fundamentally the question is if we're trusting the parole board to figure this out most of the time, whether that's 90% of the time or 99% or whatever of the time, the risk is we'll spend all of our time worrying about this relative handful of cases, trying to develop a coherent case law about what lawyers should be doing at these resentencing hearings. And we might be missing the fact that the parole board, we're just not monitoring what they are or aren't doing, and that might be where it ends. But I think the other point that I kept forgetting, and I just now remembered, was that an argument could be made that, I mean, the court has written, there was a concurring opinion in Sweet that it seemed to me was saying that the legislature, if they could pass some kind of statute that would keep judges in the loop as to life in prison cases, to allow those to come back for a resentencing, what that triggered me to think about was, what if in the case of Lyle, he had a bad day, or the trial court judge had a bad day when he was 17 or 18 or whatever, and the judge said, okay, you're one of the rare ones. You're sitting there till you're 25. Then he turns it around in a couple years, and there is no legal basis for the parole board to let him out. So that's someone that will be released in a matter of years, and per Breeden it'll be significantly sooner, and that's someone that we're then keeping incarcerated during some of his formative years. So if the legislature's interest, I think the legislature needs to express its interest by putting in place some kind of statute more than the 2.245A.
Doesn't that just make the district court operate as a parole board?
Can you ask that again? I'm sorry.
Well, because if your proposal is have the district court take another look at the case years down the road and see how the offender is doing, that makes the district court, in effect, assume the role of the parole board, doesn't it? We already have a parole board.
No, I don't believe so. The sentencing court simply has the choice of prison or probation. Or in this case, if it's a mandatory prison sentence, but without without the mandatory minimum amount of the prison sentence, then the judge is making the person available to avail themselves of the discipline or the rehabilitation that the parole board can then monitor. So what the parole board is more the surgeon and the district court is more the broadsword. I think that's my answer.
Counsel, before you sit down, it looks to me like Judge Clark looked at your client's record in prison and concluded that, he's well past his mid-20s now, and he just doesn't show any indication that he's gotten it and that he's, intending or capable of making change. What's your reaction? Is that supported in the record?
I think that within the, if I may answer, I think that the question assumes that the court is maintaining the mandatory minimum sentencing structure as for cases like Roby. So working within the sentencing structure as it exists, I think that, I would certainly concede that Roby is not one of the really sympathetic people like Contrell Jackson or Jeff Ragland. He's just not. But I think that the parts where I think that the court's ruling under the currently existing case law, such as it is still deficient because it excessively focuses on the appalling nature of the crime, and that overwhelms looking at the offender as someone who could be rehabilitated. And I also think that the biggest point of deficiency on the court's ruling is that it doesn't require any record to be made and doesn't ask about it, about what Roby's family life was like before all this started and how that still might have affected him. So, thank you.
Thank you as well, Counsel. Mr. Hanson.
May it please the court, I will agree that hopefully this is the last case in this Miller line of cases, and that is because discretionarily imposed minimum sentences are constitutional under the Iowa Constitution.
Well, do we have de novo review? Let's start out. There was a little colloquy there, but in seats, as I read seats, I'm looking for your input on it, of course, but as I read seats, it stands for the proposition that review of these cases is de novo. Is that your view too, under seats at least?
No, because if we look at Lyle, the court is very clear that the district court at sentencing should have discretion to impose a minimum sentence if it's appropriate. And
okay, good.
On appeal, the court has a more limited role, and it's not looking at a completely do-over type of sentencing hearing where looking at everything anew. It's looking at whether the court considered the correct factors, and it's looking at whether its findings are supported by the evidence. And
do you think seats is wrong then? As I read seats, it strikes me as kind of clear, and so do we need to fix that? Is that your position?
And I guess it's a problem with putting titles on it. Maybe is it when I hear de novo review, I think it's a complete redo. We
Pretty
look
much
at it,
except for credibility determinations, I suppose.
right? And I don't think that Seats or Lyle envision that that's what the court is actually doing in that situation. It's not second guessing, and Seats actually says we're not second guessing the district court's decision on appeal. We're just looking at, did it apply the correct factor?
Can't we, though, slice and dice this standard of review? Constitutionally, you're entitled to a sentencing hearing which gives the judge the complete facts so he or she can make a decision whether or not this is the rare case for the mandatory minimum. So, as the U.S. Supreme Court has done in these cases, when the hearing is improper, or they think the hearing doesn't meet that constitutional standard, it becomes a de novo review because you have certain constitutional rights at the time of the hearing. But if you're given those, a constitutional hearing, sentencing hearing, then wouldn't it might turn over to abuse of discretion because the judge did what he had or she had to do, defense counsel did what he or she had to do, and the prosecutor did what he had to do. And I think maybe that's where seats might be sliced and diced, because seats dealt with no hearing. So it was de novo, and we set up what the hearing was and how it should work. I mean, does that make sense?
Yeah, and I agree with that characterization. So if for instance, the court doesn't consider the Miller-Lyle factors, then that would be a constitutionally infirm sentence, and a de novo review would be appropriate. But again, when the court does consider all the Miller-Lyle factors, there's substantial evidence to support its findings, then it should be an abuse of discretion.
To continue the slicing and dicing more, because I think I agree with both of you. There's de novo review of whether the constitutional right was afforded. That doesn't mean there's de novo review of all the facts and decisions that the district court made once the constitutional right has been afforded.
Exactly.
Is that right?
And I agree with that. So if we start with the premise that it's a presumption against the mandatory minimum, and I think that's the law in the state, we have to figure out what type of stuff has to be before the court in order to rebut that presumption, especially if it's the rare case. And things that are talked about in both the federal and the state cases around the country is psychological exams of the child, a detailed history of the child's upbringing, programs available in the prison. I mean, this kid allegedly didn't do well in prison, but you know, prisons are notorious not to do any programming if you're subject to a mandatory minimum until you get to the end, and how parole boards treat and handle these type cases. And none of that was done in this case for the court to make an informed decision. I mean, that's what bothers me.
And I think because we don't know, for instance, what defense counsel could have done differently here, we don't know what the extent of the investigation was, if there was anything that she found that could be presented. So I don't think it's appropriate to assume that there's something that's been left unfound in Mr. Roby's case. He can certainly...
Was there a psychological evaluation of what this kid is or isn't in this record?
Not in this record, but again, we don't know. Maybe counsel looked into that, did that, and it was not favorable for him. And so we should not assume that there's something lurking out there.
Who has the burden of proof then? I mean, listen, the record's thin, right? I mean, we can all agree with that. It's a 17-page argument type hearing, and there's not much there. But if there's a presumption, and I think we say that, but I want to invite you to challenge that too, a presumption that mandatory minimums don't apply, and I think the burden's on the state to show a mandatory minimum. Challenge that too if you want. But if that is true, the paucity of the record probably cuts against the state, doesn't it?
Well, I have two answers for that. First, it's a little incongruous to say that the state has the burden to prove that Mr. Roby or any particular juvenile is that rare case, and then only give the state a series of 5 factors that are supposed to only be mitigating factors, and somehow we're supposed to use those to prove the negative.
Does the rare case even apply in this context? Again, that seems to me language that's drawn out of Miller and Ragland and the life without parole cases. All Lyle said is you need to have a hearing where the 5 factors identified in footnote 10 are considered, and the court said we're not foreclosing mandatory minimums as long as they're imposed after a hearing.
That's right.
Right.
And maybe part of the reason that this record was so thin and that doesn't necessarily cut against the state here is because even the basic facts that were presented have demonstrated that Mr. Roby does not have the capacity to change. And just looking at his disciplinary.
I think in the record, there was some concern that if the mandatory minimum wasn't enforced, he'd be out on parole? No?
I'm sorry. I didn't-
I may be mixing my case, maybe I've got the wrong case, but there, because we have another case here, but wasn't there some suggestion that if the mandatory minimum wasn't enforced, that he'd likely be out on parole?
Well, if, in this case, if the mandatory minimum does not apply, I think he will actually be discharged based on the Breeden decision, where he gets all of that earned time. He's been in for about 12 years now, which is up to that point.
Mr. Hanson,
Which is-
I know you've been getting a lot of questions and probably haven't had an opportunity to focus on some of your important points, but let me direct you in this way. You both have come into court this morning looking for a resolution of a issue that's been churning around now for a little while. And it seems that this entire movement, doesn't seem, it is, this entire movement is predicated on or understanding that kids are different, and our Constitution requires that that difference be considered in the imposition of punishment. And it began with the imposition of punishment in the most severe cases of life sentencing. And we've extended it to other forms of punishment. Kids are different. They need to be punished differently. Why is it that we as judges then, with this principle in mind, seem to struggle when applying it to these cases that now follow? And is a judge saying in resentencing, after going through these factors, that based on these factors, this kid, Roby, for instance, is not different, and we're going to treat him just like we treat an adult? Is that what's going on here? And why is it that we have this obvious struggle going on in trying to apply this constitutional principle that kids are different?
I think what the Sweet case recognized is that that struggle is much more real in a life without parole, or if we go back to Roper, in a death penalty circumstance, where the punishment is irrevocable, where we're sending a message as society.
So more judges, we can understand that. It's easier to apply in those big cases.
Mhm.
But then we get into the Roby type case, as we are this morning. Is this, did the judge here make a declaration that Roby is not different? And he's the exception, and he's like an adult, so there you go. We treat him like that, and he's off to prison on a mandatory sentence.
Once we get down on the continuum away from the most severe penalties of death and life without parole, I think when we're looking at the constitutional question, there's a higher tolerance for error. So we're not saying that Mr. Roby will be locked up for the rest of his life. In fact, we recognize he will be out of prison once he's done serving his term of year sentence. And that restores the penological legitimacy of a minimum sentence.
Getting back, I mean, following up on the chief's question, you can have factors, but the factors are less helpful unless you have an ultimate standard that you're trying to determine. What would be wrong with the standard that says, if we're not talking about life without parole, you can impose the legislative mandated minimum for the particular offense, but you have to make a determination after considering the 5 factors that this child had an adult level of culpability. Is that something the state would have a problem with?
No, and I think that sounds exactly like what Lyle discussed, where we are giving the individualized consideration to the juveniles because they're juveniles.
That case did in Lyle, inane schoolyard prank, maybe not quite inane, but certainly a youthful type of offense.
Right. And we look at a case like this one where the act spanned many years. There's really no indication that the infirmities of youth affected Mr. Roby's,
Sure there is.
decision.
I mean, he was, I mean, a lot of it, it ended at age 18, I guess, and much of it was earlier, 16, 15, so forth. The general principle is that youth do not have sensible cost-benefit analysis. They don't have judgment. They act on impulse and so forth and so on. That's all over this record, it seems to me. Now,
Well, I would push back. I don't think you can impulsively sexually abuse somebody over and over and over for years and years and years. That's not impulse. Also, he had special knowledge that what he was doing was wrong. He had been confronted by this family before.
sure, but
He had
that's,
experienced the consequence of being kicked out of the house.
What
So-
about his Navy? You know, he got into the Navy, he was maturing, he was fitting with authority, he had a structured setting that seemed to set him down the straight path, and then he got pulled out of the Navy, of course, when these allegations came. I mean, how does that cut in this record?
Well, I don't think his, how he would behave in society unmonitored can at all be determined from how he behaved in the highly structured environment of the Navy.
Yeah, but you always hear, you know, go to the Army, young guy or young gal, because it's gonna straighten you out. You know, and you talk to all these vets, and it just saves their lives, you know? They were aimless, and they came out with direction, with maturity, with things like that. And, I mean, that says something about this kid. He may have been a screw-up when he was 16 to 18, but when he got into the Navy, it looked like he was functioning well.
And I think what you're getting at there, or how I would respond to that, is we're not looking for the perfect sentencing practice. That's something that belongs to the legislature. The Constitution should operate in the margins and only go after those sentences that are so extremely unreasonable that the court is required to overstep the bounds of the separation of powers and step in and undo what the legislatively elected representatives have imposed.
Chief, could I ask one follow-up? You were invited earlier to respond to whether the state's position, is there a presumption against mandatory minimum on these shorter sentences? Sweet involved, you know, life sentence. I haven't seen that presumption in any of our cases. Have you?
Not in a lower minimum for a term of years, no. Seats mentions, I think, a presumption that most juvenile sentences will not end up with a mandatory life without parole. I don't know that that's the same as the presumption that, a presumption of proof. It's just a presumption of how most of them will end up after the sentencing hearing is given, not a presumption that we're starting at a certain point or
Would the state advocate that we should not impose a presumption against minimum sentences on our sentencing courts in view of the legislature's decision to allow them?
And I think that's the best place to start. Is this is the legislatively mandated sentence for this crime, and it's the defendant who's seeking a constitutional relief from that sentence.
we ignore the youth are different.
We're not
and we-
ignoring that
we
youth
ignore
are
the
different
science.
because he gets the benefit of the individualized sentencing hearing.
And if there's no evidence presented at the hearing of any kind, the presumption is what?
Well, the presumption would be that the legislatively enacted punishment applies.
That's a
And-
180 from our other cases, though. I mean, if you know, we said in seats, the presumption is against life in prison without parole unless you have the hearing doing something. And we don't have to say it in Lyle, because you can't do it. You can't give the minimum without the hearing. So it follows logically that there's a presumption there until you go through the sentencing hearing. And the court does everything to determine that this kid should be treated like an adult. So I don't know how you can say there's no presumption.
And I think the problem maybe is that we're picturing a hypothetical case that has not occurred, where it comes to sentencing on a juvenile case and the Lyle Miller factors are completely ignored. That hasn't happened. It didn't happen here. And in fact, this is a particularly bad case to make a broad categorical rule, because Mr. Roby was resentenced 10 years after he was first put in prison. So we're not, like in Sweet, trying to look forward and predict how he will end up. We're actually looking back to see how he's performed and how he's rehabilitated himself. And because he has not demonstrated that capacity for change, this court should reject the categorical rule and affirm Mr. Roby's sentence. Thank you.
Thank you as well, Mr. Hanson. Rebuttal?
5 minutes? Thank you. Well, again, I think we could talk about just this for the rest of the morning or all day. There's so much to unpack. I think that to add to the list of things, Roby wants a PSI. I would like clarification about abuse of discretion or de novo, and I think adding to the list of things is the court has to decide whether there is a burden of proof or a presumption in cases where the amount of damage inflicted by a wrong call, by a bad call by a trial court judge happens to be less.
Follow up on that, because you talked about Apprendi the first time you got up, and I've thought about that too, and I think it's a serious issue. In other words, if you take Breeden and you take Apprendi and you say that the state has the burden of demonstrating that proving up that a mandatory minimum is appropriate, if we say all that, then wouldn't there be a right to a jury determination for a juvenile facing a mandatory minimum? Is that right?
I don't see how that doesn't follow.
Now, let me ask the other question. If you, as a defense lawyer, is that what you would want?
What I would want as a defense lawyer, and this is kind of tying into the separation of powers argument, what I would like to see is the legislature drafting up statutes that actually allow the development of a meaningful body of case law and have some kind of objective factors instead of kind of this retrofitted lawyer debate contest that we have now. And I mean, and the state's correct in saying Roby's been in prison for 10 years, but this is that is a range of facts that is done. And going forward, the courts are going to be in the position, short of a second trial, the courts are going to be in the position of having to guess how these kids are going to be doing for the rest of their lives. Well, no, not for the rest of their lives, but then to borrow that line of cases into this, kids are different whether it's life sentences or less than life sentences. So if the premise is life sentences deserve a special treatment, then maybe a different result is justified. If the premise is kids are different, then we've just had several cases to demonstrate to the court how well this sentencing structure as it presently exists works. And it's the same sentencing structure whether it's lifers or less than life cases. So I think I'm deviating off your question a little. Did I?
Understand, you might be better off with judge sentencing than jury sentencing.
Oh, well, that assumes that I don't know what the results of all these things are going to be. I just think that based on, I have no idea whether juries would punish a sex offender like Roby more. They very well may. But I don't see how, once you set in motion this chain of events, I don't see how you don't spring into existence an Apprendi and a Blakely claim.
Sure, because, I mean, I see the issue, it's a substantial issue, but if the claim is one of constitutional power, it may not be a question of who decides it. I mean, but let me ask you this. Assuming, I mean, just go under Lyle. Make your case why you think the mandatory minimum ought not apply to your client based on the record that's been developed.
Oh, well, based on the record that's been developed, I think a remand would be appropriate to figure out what, okay, just based on the record that's developed. Well, yeah, and I think that's always available, but I think that the Miller factors themselves, as applied to this case, the weakest point in the court's ruling is that it conflates the family and home environment with the scene of the crime, and therefore it doesn't look into whatever Roby's life was like before he came to live in this household. I think that's the weakest point, and I think that the court gets too outraged about the nature.
But was there a reason for the court to address that if the parties didn't put on any evidence about that? I mean, there was scant evidence about the family of origin.
Well, if we're starting with the idea that there's a presumption, I don't see how a 14-year-old who is acting out sexually, how you can't start to say, wait a minute, what was his home environment before?
Take then
this?
as the state's argument that it maybe started at 14, but it continued on for several years.
Sorry?
Sorry, the state's argument was that, well, perhaps the initial offense began at 14, it continued on for several years, and the state's suggesting that
Well, and even under the Miller factors, I think, may I answer? Even under the Miller factors, I think that actually in kind of a way, this might be a somewhat distasteful thing to say because it's a sex offense case, but a 14-year-old acting out sexually, if that family had started up juvenile court proceedings, you can get a 14-year-old into sex abuse counseling and get them turned around and get them to stop, and that did not happen here. So I think even under the Miller factors, that's a valid point. So, thank you, Your Honors.
Thank you as well, Mr. Audlehelm. The Roby case is then submitted. We'll now hear the arguments in the detention of Jeffrey Anderson.